It is April 25th of 2026, and this is the Court Gallery. Welcome to the Weekend Case Review, ladies and gentlemen. You're about to hear a powerful victim impact statement from a woman who was scammed out of $45,000 by a contractor. Then we'll see Judge McNally confront a defendant who's been missing for 3 years, and he remembers it. Judge Stewart is blindsided during a domestic violence sentencing when the victim suddenly changes her story and dumbfounded by the facts of a high-speed chase where the defendant says he was just panicking. Finally, we see Judge Ricke put a pin in a 2-county crime spree. I had some doozies on the cutting room floor this week, ladies and gentlemen, and we're going through some of them right now.
Mr. Flodine.
Meet you.
He wants his, I made one change on the DGOC. He wants his payments to be on the 18th of the month, not the 1st of the month.
Okay.
Just for
Are you
bill
still in
paying.
Nebraska?
I am.
Okay, same address?
I just updated it.
Okay, outside?
No, like a few days ago.
Let me just check.
8405.
You did. Okay. Telephone still ends in 7060.
Yes, Your Honor.
Do we have victims here, Miss Bauer?
Yes, Your Honor.
Okay. We will go on the record in the matter 25 CF 140, State of Wisconsin versus Mica Flodine. The state appears through District Attorney Kevin Schmidt in person. Mr. Flodine appears in person with counsel Daniel Chapman. We're set today in this matter for a plea and sentencing. Mr. Chapman, please place the agreement on the record.
Your Honor, as a bit of background, Mr. Flodine entered into a deferred judgment of conviction for very similar conduct. This is simply a matter of another victim came forward after those matters were resolved. The matter involves another deferred acceptance of a guilty plea agreement and a plea to theft by contractor with agreements that he continue to pay restitution, and we stipulate to the restitution amount.
Now, I am quite familiar with the last go around. Is this an additional monthly payment on top of his other deferred?
His other restitution should be paid off this summer, and these payments will begin on August 18th.
That's excellent.
That's why it's staggered for when it starts when it does.
Okay. Well, that is good to hear with that case. All right. And so we do have a victim here who would like to make a statement. I'm going to have her, okay, come on up here and have a seat right there at the black desk. You can either state your full name or you can just state initials, whatever you prefer.
My name is Tammy Klatt.
How do you spell Klatt?
Klatt.
Thank you.
And I can say how this affected me. I feel that Burnett County did not protect and serve my rights. They did not care about my rights whatsoever. I entered into this agreement with Mica, I believe in June of 2022. It was reported to the Burnett County Sheriff's Department in the fall of 2023. Or no, I'm sorry, 2024. It took numerous phone calls to Burnett County Sheriff's Department to find out what was going on. I left messages with the sheriff herself, no return calls. There's one person in the DA's office that I could call and talk to that actually listened to me, empathized with my case. And in between this time, I also did research to see that numerous cases like this had been going through court with the defendant. And it was very frustrating that it took so long to get my case to trial and be heard. In fact, to the point where we're almost at the statute of limitations. And then being told by the DA that I have a choice, that either I can get my money back or criminal charges can be placed. But if I were to go for criminal charges, he probably wouldn't end up in jail, that he'd be let out soon. And then definitely no guarantee that he'd have to pay the money back. So, and I understand as your position, you're upholding the law as it's written, and there's nothing you can do about that. I think that is absolutely pathetic because it doesn't protect the innocent people. To me, that helps criminals. I also submitted the money that was spent to get preparations for this building to be built, and that was denied. That could not be submitted to be as paid as restitution. So basically what this situation has told me is that somebody can steal $45,000 from somebody and they'll have to pay it back, but not with interest. And it may take 3 or 4 years before they have to start paying it back. And then it's just a monthly payment.
If you want to explain a little bit more, I only know what facts are in the complaint. What were you trying to build?
A garage, a big pole barn, basically. And he came and put some of the post frames out and then just left. And initially this caused lots of arguments between my husband and I because I wanted to take him to court right away. He wasn't returning. We sent several messages, phone calls, and nothing. And my husband was more, let's be nice about it, sort of thing, and we'll get more done. And I'm like, no, he walked away. Let's take him to court. But I listened to my husband. And so the frame was there. So finally my husband said, if you don't come and fix this, I'm going to contact an attorney. And he sent him that text, I believe in May, and said, if you're not here by July 15th to replace these rotted frames that sat all winter long, that are no longer good, and to start building what you agreed to build. And he showed up on July 12th to remove the frame that had sat through the winter and then put up another frame and left it. And then when I saw on Facebook Marketplace that he was selling all of his tools, I messaged him. I said, so you're not coming back? And he's like, no, you're next on our list. This was in October of 2024. You're next on our list. We're going to be right there. And then I saw him post in South Carolina of a beautiful roof he had just finished, him and his guys. And so I made a comment on that post saying, are you ever going to pay the people in Wisconsin that you owe money to with this? And I was blocked. No response, no nothing. So that's my frustration.
Thank you, Ms. Clapp.
Mhm.
You want to go have a seat in the back, you may. All right, so Mr. Flodine, you are going to plead to the felony, is that correct?
Yes, Your Honor.
So I have in front of me, well, it's one count. Greater than 10, but less than $100,000. Doesn't matter which count it is that he's pleading to,
No,
2 or 3. He pleading to 2, well, 1, 2, or 3, I guess. Theft by contractor greater than
I
okay.
was gonna say, I think there's just
Yeah,
one
it's
count.
2 or 3. So we'll go with count 2.
Judge, there's only one count.
Yes,
Oh, sorry. I'm sorry. I was looking at the old case. I pulled up the old deferred to see the difference. All right, so you're
Process of
pleading
pulling
to
that up
the
to
sole
verify.
count. Theft up by a contractor greater than 10 but less than $100,000, a class G, correct, Mr. Flodine?
Yes, Your Honor.
I have in front of me this plea questionnaire waiver of rights form. I also have in front of me the deferred judgment of document or deferred judgment of conviction document. Did your attorney thoroughly go over those with you?
Yes, Your Honor.
Did he essentially read them all to you word for word?
Yes, he did.
Did you sign both of those documents?
I did, Your Honor.
Attached to the plea questionnaire, I do have what the state would have to prove your guilt beyond a reasonable doubt, as well as the maximum possible penalty. Did your attorney thoroughly go over that with you?
Yes, Your Honor.
So you fully understand everything contained in both of these documents?
I do, Your Honor.
You're 38 years old. You have 12 plus years of schooling. You can read, write, you understand the English language. You do not have any drugs, alcohol, or other medications in the last 24 hours and no mental illnesses or disorders.
Yes, Your Honor.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on the first page of this plea questionnaire. Did your attorney thoroughly go over those rights with you?
Yes, Your Honor.
Do you understand them completely?
I do, Your Honor.
Do you need me to go over those rights with you in any more detail?
No, Your Honor.
You understand that by pleading guilty, you're waiving and giving up those rights?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
Do you understand that you are pleading guilty to a felony? As such, if judgment is entered, you will no longer be able to use or possess a firearm for life.
Yes, Your Honor.
No longer able to vote in any election until your civil rights are restored.
Yes, Your Honor.
And do you understand here the state would have to prove that on or around November 24, 2023 in Burnett County, Wisconsin, you entered into an agreement for the improvement of land. You received money from the owners JK and TK, and without consent of the owners and contrary to your authority, you intentionally used any of the money for any purpose other than the payment of claims due or to become due $44,173.71 from you for labor and materials used in the improvements before all claims were paid in full, contrary to Wisconsin law. Do you understand that?
Yes, Your Honor.
Essentially, your attorney has it much clearer than the criminal complaint. You entered into an agreement with another person for the improvement of land, here a shed, correct?
Yes, Your Honor.
You received money from the owner of the land under that agreement, correct?
Yes, Your Honor.
You intentionally used all or some of the money for a purpose other than the payment of claims due from you for labor or materials used for the improvement, correct?
Yes, Your Honor.
And you did so without the owner's consent, correct?
Correct, Your Honor.
And you did so knowingly that you were using the money without consent and contrary to the authority you had under the agreement.
Yes, Your Honor.
You understand the maximum possible penalty could be a fine of up to $25,000 or imprisonment of up to 10 years or both.
Yes, Your Honor.
Do you understand that I'm not bound to follow any type of agreement? Do you understand that?
Yes, Your Honor.
Do you understand the terms of the deferred judgment of conviction document if accepted by the court?
Yes, Your Honor.
Do you understand that you would have to pay every month an amount of $920 beginning August 18th, 2026 until total restitution of $44,000 is paid? Do you understand that?
Yes, Your Honor.
Do you understand that this agreement could be terminated after 48 months if all restitution is paid in full?
Yes, Your Honor.
You understand that you must pay to the state $150 prior to 60 days expiring.
Yes, Your Honor.
Did you go over the criminal complaint with your attorney? In particular, it's that section where it basically says what happened around that time and why you were charged with this crime.
Yes.
For the most part, are those facts accurate?
Yes.
Did you in fact take money as a contractor greater than $10,000 but less than $100,000?
Yes, Your Honor.
And you had no consent of the owners to do so?
Yes, Your Honor.
And that was not in line with the agreement that you entered into?
Yes, Your Honor.
Mr. Chapman, may the court use the probable cause section of the criminal complaint to find a factual basis as well as the statements made by your client?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to this charge?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes, Your Honor.
and voluntarily?
Yes,
Has your attorney represented you competently?
he has.
Has he answered all of your questions?
Yes, Your Honor.
Has he looked at this matter thoroughly?
Yes, Your Honor.
Are you satisfied with his services?
I am, Your Honor.
Any questions for the court or for your attorney before I proceed?
No, Your Honor.
As to count one, theft by a contractor greater than $10,000 but less than $100,000 as a Class G felony, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of theft by a contractor as a Class G felony. Mr. Schmidt, argument as to whether or not to accept.
Judge, I'd ask you to accept the deferred judgment conviction. Had our office known about this back when this happened, it would have been part of the other one. We know that the deferred judgment conviction in the other case worked, as the victims are about to be made whole on that very soon. In this case, financially, the victims will be off better than if this went to trial and we won and we had to do a restitution hearing. I think the court gathered from the victim here that they have very negative feelings about what happened to them with what happened with Mica Flodine. It felt like a betrayal. The crime that Mica Flodine committed here is theft by contractor, which, despite how the statute is titled, it is the offense of using any of the amounts that were given in the contract for a purpose other than the contract before all claims were done and due. What that means is it is not a crime to take a job and not finish it, is not a crime to do a bad job, is not a crime to breach a contract. Those are all things that Mica Flodine did, and the victims are very harmed by it. In this case, you know from hearing the victim statement, Mica Flodine didn't just take the money and disappear. He did do some work. He did buy materials. The $44,173.71 that were paid to him, he did use some of it on the job. He wound up not finishing the job. In this manner, by getting the full refund of the amount initially paid, the victims are being better off with this agreement financially than alternatively. I think that's the most important thing in this case, to make them whole on that. I think that the deferred judgment conviction has unique features in that by having the incentive of having it discharged at the end, a person is likely to pay off that amount. We've seen before, when we send people to prison on large cash restitution cases, the court loses the ability to really be a stick on that. The court can't revoke someone's extended supervision in doing so. This is a better way of doing it. This is of more value to the victim than just having a civil judgment converted from a restitution judgment at the end. And it's a higher amount than it would have been either. For that reason, I think this is appropriate, and I'd ask the court to follow it. Thank you.
Thank you. Mr. Chapman.
I also think it's important to say that Mr. Flodine didn't just pocket the money and go take a trip to Vegas with it. He got in over his head and was using funds from one job to try to complete another job. And in the process of juggling all that money, he went broke. He didn't have the money to complete the job. He didn't just take it and run. But he has dug himself out of that hole, and he has paid a massive amount of restitution already. And I think the most important argument for why the court should accept this agreement is that the previous agreement he entered into years ago was successful. The victims are going to get their money in this case. He wants to pay it back. And he didn't delay any of this. It would have been in his legal interest to take care of this back in 2022. So we're really just continuing the agreement from 2022 to take into account the newly discovered amount of restitution. And yes, Mr. Flodine is agreeing to pay that entire requested amount without nitpicking about, well, how much money was spent on foundations that was laid. He's just agreeing to repay it. So I agree. I think this is an appropriate resolution, and I would ask you to adopt it, please.
All right, thank you. Mr. Flodine, is there anything that you want to say? You want to make any statement here today?
I do have one. If I could use my cell phone to read it, I've written it.
Ken, if you are going to read it, please read it slowly and enunciate your words so that the
Okay.
court reporter can take everything down.
Your Honor, I want to begin by saying I'm truly sorry for my impact my actions had on the residents of this county. This community was my home for 36 years. I grew up here, built my life here, and I truly love this place. It weighs heavily on me knowing that my actions affected a community that meant so much to me. I also want to sincerely thank you and the district attorney for your time and patience and understanding throughout this process. This situation has humbled me, and it's forced me to take an honest look at the decisions and take full responsibility for where I went wrong. I believe the Lord has used this to get my attention and redirect my path, and I made the difficult decision to leave my hometown and step away from everything familiar so I can focus on becoming a better man. I've been working to live with more integrity, accountability, and purpose. This has come at a personal cost. I've lost friendships, and there were months where I had to choose between basic needs and making restitution. Those experiences changed me and helped me understand the weight of my responsibilities and the consequences of my action. I take full responsibility for what I did. I've learned from this, and I'm committed to making sure it never happens again. Moving forward, I want to use what I've learned to help other contractors avoid making the same mistakes. I intend to work with the Wisconsin Department of Safety and Professional Services and Wisconsin legislators in any way that I can to improve the understanding and help prevent situations like mine. If I can help even one person avoid this path, then something good can come from it. I'm committed to continue to grow and do better and make things right moving forward. Thank you.
Thank you. Mr. Flodine, I hope all of that is true, and I hope that this is true remorse, because Ms. Klatt is not the first person that I've heard these stories from, as you're aware, and that it impacts them more than just a financial level, because it impacts their emotions, it impacts their life, and it caused, as you can hear from Ms. Klatt, tension in her marriage, and all of those types of things. So it's not just a financial crime. It has had other significant impacts. If I were to send you to prison for this, and quite honestly, it should be a prison case, especially with the other matters. Mr. Schmidt is right. I lose control. I can't then ensure that you're going to continue to make payments and to attempt to make the victim whole. It's not going to make her whole. It's not going to make her and her husband whole, because a lot more damage has been done. And I agree with the statement made that there should be interest attached, because they had to expend $44,000 back in 2022. And had that been in a bank account, they would, even the smallest interest-bearing bank account, they would still have more money than that. And I understand Mr. Chapman's argument of they have the foundation, they have the original, the footprint of where you were going to place this garage. But who knows if that was sound? Who knows if they were able to keep that? Who knows if that was able to be used by the next contractor? I am going to say as well, you're not the first contractor to have been put in this situation, or where you have indicated, or your attorney has indicated, that it was a steal from Peter to pay Paul type of situation. We do have other contracting cases in our small little counties, theft by contractor. It's prevalent.
Yes.
And it's awful. And in the end, where is the justice? Because it's not to the Clatts who haven't gotten their money right away, or they couldn't use that money. They had to find other funds to be able to build that garage that they were hoping to have. It impacts our small communities immensely. As much as there should be punishment, there should also be as close to a guarantee that the money, the $44,000, will be paid back. And with the deferred judgment of conviction, that's the only thing that can guarantee that. I put you on probation, and all it's going to do is continue to have you in my court, and either you're going to be paying or you're not, or I'm going to throw you in jail for 20 days, and then you're not going to be working, and we're not going to get the payments. And you'll just be on probation for years and years and years and years. Here, this says 60 months, so 5 years that this could run. I'm sure hoping that you're going to pay a lot quicker than that, perhaps how you paid off the other matter in your 22 CF 238 case.
That's the intention, Your Honor.
Because I believe the Clatts have waited long enough. And if the court accepts this agreement, then I accept this agreement. I do recall in the last agreement that I modified the deferred judgment of conviction and said that at the time you were selling your equipment and then you were moving to South Carolina.
South Carolina, yes.
And then now you're in Nebraska.
Mhm.
But you don't own your own business, correct?
No.
You work for a business.
Mhm.
And at that time, I had modified the agreement to say that if you paid it off within 1 year, that was for a 3-year term, but if you pay it off after 1 year, then it could be terminated early.
Mhm.
That's an incentive to try and get you to pay it back faster. Here, there was 20 or so more thousand that you owed in that case. I want to see that incentive here as well, because I do believe that the Clatts should be paid back in a quicker fashion than 60 months.
Yes, Your Honor.
To me, that's kind of pitiful, actually, since it was from 2022, 4 years ago. So I am going to say that if you get this paid off, you can somehow figure it out. And that's having a strict budget. That's not having a $60,000 or more vehicle to drive in. That's not having, the best phone or all of the things, and maybe not having any streamings and just using the free apps to watch TV or those kinds of things. If you can get it paid off in a year and a half, then this can be terminated. I want that to be your goal, because I'm going to tell you in the end, you're the one that's winning more, because you're not going to have that felony hanging over your head. And then hopefully the Clatts can get their money quicker and they can move on from this. They're not going to move on. I can tell you, they won't move on until that every dollar is paid in full. And then after that, they will be able to start moving on from this. So I will accept the agreement as it is, and it's been modified by Mr. Chapman for the 18th instead of the 1st. And I will write that if you pay off all restitution in a year and a half, it can be terminated. So I will adopt the agreement with those 2 modifications. Anything further?
Not from me.
Mr. Chapman?
No, Your Honor.
All right, then thank you. We are adjourned.
Thank you, Your Honor.
People against Jamie Antonia Williams Bay, 23W831 7 through 6. Come on up to the podium.
Right to the podium. Good morning, Your Honor. Mr. Chunky, Mary, my client just stands to my medium right. You say change correct, sir?
Examine on the back.
Give me 1 second. I'm curious as to what prompted her or him to come in here. Or her
It's
to come in.
I misspoke, Judge. It's
Right. What prompted her to come in today?
Your Honor, she had
I remember this one. You know what? That's pretty amazing, isn't it?
I say I already told him. I already know I'm about to get scolded.
Get a scolding. You haven't been here in 3 years. If you call that a scolding, I call it disrespectful for you not to show up. But I remember this case, and that's never a good sign. 3 years later, I remember this case because your attitude was,
So,
and now you've seen the light. Where's she been for 3 years?
Your Honor, she is now gainfully employed in college. She had a period of time where she did not have any lodging, and she's gone through an ordeal, but it does appear that she's made some positive strides. And she's not arrested on a new charge or anything. In fact, she called the police for assistance, and it was at that time they discovered that there was not a standing warrant. But she's not getting picked up on a new case.
Is Heather here, Jennifer Wiseman?
Yes, she is, but I can pull something up if you need me to.
Yeah, pull this case up.
Go ahead.
I
Do you have
sensed
the case number by chance that I can?
23W 831 736.
Thank you.
So I sentenced her, it looks like, back on June 21 of 23. I set a review hearing. Well, then she failed to appear on October 2nd. It must have been a show cause. It was a show cause. So let me find that show cause and we can go from there. I don't know. Okay. The charge is fair to pay fines and costs as ordered. This is part of a show cause dated September 18 of 23. So have you had a chance to look at that with her or talk to her about that?
No, Your Honor, I saw that there was an outstanding fine, I believe, and that there was just a bit of apply with all terms and conditions. I was more concerned with the amount of time that's elapsed since the last show cause.
So I'm going to arraign her on that. And then I'm going to go from there, okay? Ma'am, you're charged with failure to pay fines and costs as ordered. This is part of a show cause dated September 18 of 23. And you didn't show up. That's your first technical violation. However, now you've absconded. So that means that your height of status could be revoked. I don't believe I ever revoked that status. The conviction entered. And you would be subject to a 90-day jail term. Do you understand?
yes, sir.
You are presumed innocent. They have to prove you guilty by a preponderance of evidence on this, since it's a probation violation. You have the right to a hearing. At that hearing, you have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, at any time, you'll be giving up all those rights, and we're not going to have a hearing or a trial of any kind. You understand that?
Sir.
All right. You understand at a hearing, you could testify or remain silent. If you remain silent, that silence would not be held against you, and you'll have the right to cross-examine any probation witnesses. I can't hear you.
Yes, sir.
All right. So in a second, I'm going to ask you how you wish to plead. Is she going to plead guilty or?
Yes, in these circumstances, it's a black and white situation. She knows that she did not make a payment, and she knows that she failed to appear. I don't believe that the hearing would be necessary that, but we will be wanting to provide an explanation. But yes, in the circumstance, we're not contesting those two scenarios.
John Colin, Beth, to the charge that you failed to pay fines and costs totaling $935. How do you wish to plead?
Yes.
Did you fail to pay?
Yes. Yes.
I can't hear you.
Yes, sir.
Anybody force you to plead guilty?
I'm just ready to go ahead. I'm just trying to get this. To get back to church.
Plea is accepted to that charge. I find it to be an accurate plea made voluntarily and understandingly. Here's my concern with you. I bet you didn't do the community service either. And I bet you didn't do the positive strategies program either.
Definitely did human service and a positive strategy.
Let me
And I sent her emails, and that's why I had tried to contact her.
just keep your voice up.
I just tried to contact her on email and just let her know like I couldn't make it. So I was just trying to, let y'all know so y'all can another day or just so I can get here. And I couldn't. And it's like everything just fell apart, and I couldn't even get here. So
You couldn't get here.
it really was after the fact, and I couldn't get up here and what I was doing with my life, honestly.
When you got here to this, you got here to the Speedway on Allen Road in Woodhaven, and Allen Road's right next to us.
Yeah,
That's when you committed the crime back in February of 23. And then I heard all this from your lawyer and you about how your employer, right? Correct me. These were lottery tickets. Yes?
Yes, but I'm not gonna lie. I feel like honestly, I feel like they threw me under the bus. I wanted to take that to trial. I didn't know how and what to do. And honestly, I was geeking. So
You were what?
I feel like they threw me under the bus because it wasn't me doing it. It wasn't me doing it. So and they wasn't giving y'all no cameras or footage, anything, and I didn't know how to go about it. And no knowledge, none of that. So of course I was angry. I was scared. I didn't know what to say.
I wouldn't have taken your plea if you didn't admit that Ms. Murphy was representing her. I remember this vividly. And she was saying that at least initially that the employer asked her to steal, her boss asked her to steal the lottery tickets. That's what I was told. I'd love to go back and listen to this. I mean, I give myself credit for even remembering any aspect of this, given the fact that this all happened 3 years ago, and I've only had probably 8,000 people in front of me since then. I want to know why she didn't show up. And I want to know why she didn't come and ask for time to pay when I told her she could do that.
I really ain't had I didn't have nobody. I didn't have nobody to, you feel me, to tell me that this is what you gotta do. If you don't do it, you definitely gonna go to jail. Just I've been through so much since I haven't been here. So like I got a lot of knowledge now. I go to school for criminal justice, so I know there's certain things that you have to do, but there's certain things that you feel me, that you just gotta.
You're going to school where for criminal justice?
Oakland Community College. Yeah, I'm about to graduate actually.
With an associate's?
So
Do you have proof of that?
it's on my phone. I got everything. I got a FEMA certificate. I got the first year on it. I do.
Your name?
Elizabeth lost probation, Your Honor.
Did she do the positive strategies program in the community service?
She did do her community service, Your Honor. She did not attend the positive strategies program. She indicated to me that she was struggling financially. I actually worked it out with PRS. They waived a lot of her late fees and courtesy fees, so she could attend that program. But no, she did not end up attending it.
Ma'am?
Yeah, the last communication from PRS was that she wanted to share another update with me. She had to reschedule her session from the night before, waived her fee as courtesy. Unfortunately, she failed to attend the scheduled session again. That is from Kristen at PRS.
Jennifer, give me a new Woodhaven date real quick.
Sure.
Let me just double check something. How much trouble have you been in since you were in front of me? Oh, you went out and got something else. You got a CCW dismissed because it was under HIDA.
Yeah, it was.
You still have warrants. Let me see how many warrants you have here.
I didn't have no CPU.
Here's what you have. Warrant out of the 24th district, warrant out of the 23rd, 53rd, 37th, 46, 36, 36, 36. You got about 8 warrants out.
Right now?
They just ran this today.
What? I don't know. I only thought I had the ticket more, so I'm not even worried. I'm not even what's it called. Like I went on my I needed my driver's license. I literally got to pay 2 no insurance tickets, which I did have insurance. I just
Ma'am,
didn't get.
let's stick to the issue.
Yes, yes, sir.
Do you work?
Yes. I'm okay. Amazon. I've been working here for 4 months. Going on 4 months. Be there every day. Thursday is the only day I don't be there because I can't work.
Why should I not revoke her height of status?
Yeah, I think that bringing it
She
down.
didn't do the positive strategies and she's been blowing us off for 3 years, 2.5 years.
Judge did indicate that he'd be seeking potentially another day in Woodhaven's here. I think that some of the statements that she's made regarding school could be verified and maybe that put her in better light for reconsideration.
You have the money now?
I definitely can pay you good. I can go on my mic pay, get you 200, pay 200 today.
Well, you owe us over 900.
Yeah, 935.
No, you owe more than that now. There's warrant fees and everything else. You came here after 3 years and you came here with only $200. I mean, you knew you owed at least 900.
I don't get paid till Friday. Sorry. I don't get paid till Friday. And then I just gave my auntie Ricke so
Give your auntie what?
rent money, so I didn't listen. I got a lot. I still got a lot going on. I want to get this out the way. I'm not gonna lie. I definitely trying to get this out the way. I definitely told him I'm trying to get this settled. You know, because I already know. I knew this was gonna come back to me. I just didn't know it was gonna come back today. And I should have been got it together. And that's just me not having, you feel me? Yesterday was my daddy death day, so it's not like I feel me. Everything just fell apart. When we give up work at 3 in the morning today, like,
I know, but you remember what an attitude you had with me?
yes, and I apologize because I was a kid. Didn't know nothing.
Well, you act like you've grown up by 28 years. This was only 2.5 years ago. You were born in 03, right?
Yes, sir.
I'm not amused.
I don't, it's not like I got any items. I don't got nobody to look up to. I gotta do something.
Where's your mom and dad at?
Dad passed. So, and my mom, you really don't.
I can't hear you.
Dad passed. Me and my mom were not cool. So,
You're not cool? You don't get along?
very.
You're not showing her enough respect.
No, it's not like she give her kids that type of respect. You know how these generation mamas be. Want to do what they want to do. I take care of their kids and treat them and show them the right way.
Here's what I'm going to do. Jennifer, give me a date when Mr. Urick's on my docket, will you please?
You've got April 29th or May 13th.
Beth,
Yes,
positive strategies program.
yes.
How long until she could get into that?
I honestly, I'd have to look at the website. It's offered, about once every about 4 or 5 weeks. I am honestly gonna go off memory. I wanna say it's being offered like the second Thursday in May, like May 13th, maybe. I don't know.
Give me
Again,
a later date in May.
The 27th.
And how many days is that program again? It's just,
it starts with the initial. and-
right, but I didn't order any follow-up, so it should just be one day, right?
Yeah, it should just be one day if no follow-up was
We're
ordered.
gonna set a sentencing for, what'd you say, Jennifer?
May 27th.
At 8:30 in the morning. Now, I'm setting a $200 cash bond. I'm accepting your guilty plea. I'm gonna write down here, defendant 2, attend positive strategies program. Let me tell you something. If you're truly, and bring proof, bring proof.
Bring it out.
Defendant attending criminal justice program at Oakland Community, I'm sorry. Listen to me pardon me?
This is literally my last semester. I'm supposed to graduate on.
Well, I tell you what, you can take a criminal justice degree and pretty much throw it down the garbage if you're convicted of things like this in CCW. Now you got the one off your record, and you better go over and take care of at least a couple of these warrants. So I'm giving you 5 weeks here. It's going to take care of at least a couple standing warrants?
I didn't even know I had any. You know what I mean? I don't even know how. It's-
So even though you were wise with me and disrespectful,
I'm not apologizing.
that's the beauty of the criminal justice system. I'm still gonna treat you fairly. You're gonna post $200. Jennifer, tell Heather or whoever to
I
print out a
am
note.
relaying it right now.
Thank you very much. May 27th at 8:30. Take care of a couple tickets. Do the hang on. Do the positive strategies program, and you better come back with all the money here too.
Yeah, I'm.
Listen, this is it. I can't extend probation anymore. So you gotta come back with, there's restitution of $300. So you're gonna be able to come back with the other 700 in 4 or 5 weeks?
I'm not gonna lie. I was about to just ask you, like, can I pay it through the 7 weeks? That's what I was telling
I
you.
can't do it.
So you just want me to come with all of it?
You have to.
Yes, sir.
If you want this off your record, you have to,
Yes, sir.
okay?
Sir,
In fact, if it will help you,
In 13,
just wait 1 second. You're mumbling. Just let me finish, please.
I'm just happy. I'm sorry.
Happy.
But like, I'm just tired of talking. Sorry.
She did this before too. She won't stop talking.
That's my part. That's what I'm in therapy for.
Court will consider not requiring you to take care of other tickets. I mean, you're still gonna have to do it. If D comes with all money. I can't dismiss this for you if I don't have all the money. I can't do it. You had 3 years, 2.5 years to save. That's all I can tell you. Post your bond. Good luck. I wish you well. I hope I can dismiss this for you. Good luck. Thank you.
Thank you, Judge.
Thank you, Judge.
And I do note that Mr. Goins is present at this time. So, Mr. Goins, what I am going to do is I will take testimony from you. I'll allow Mr. Colby to respond or place testimony on the record if he desires, and then I can make my ruling on your appeal. So, Mr. Goins, would you please raise your right hand? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes, Your Honor.
Very good. All right, and Mr. Goins, you based your request for a PPO based on, you describe it as cyberstalking. I take that that's a violation of Michigan cyberstalking statute, in that he posted messages about you, as well as photographs of you that you believe are from your criminal case, discussion of the case, and caused you to fear for your life. Why don't you describe the dates and times of those messages you're talking about?
Also just criminal stalking as well.
I'm not here to evaluate criminal stalking. It is the same language under the statute.
Okay, long as we're on the same page, Your Honor.
Yeah, I understand what you're claiming.
So go back to January 29th, 2026. Petitioner followed me to the local library. When I came out of the library, he was there. We locked eyes in contact, so I can verify that it was him. And then later that night, he posted.
Let me just pause you. When you say he followed you, you mean in his vehicle or on foot?
Yes, Your Honor.
Which way? Walking, or was he in his car, or was he on his foot?
We were both. So I was leaving the library, and he was coming by the library, looking right there at us.
Walking or driving?
Driving, Your Honor.
Okay, so he was driving his vehicle and followed you and your girlfriend in the vehicle?
I don't have a girlfriend, Your Honor.
Okay, who else was in the vehicle with you?
It was a friend.
And who was that?
It was a tenant or a landlord of mine, Angela Taylor.
Okay, all right. So you and Miss Taylor, you're leaving the library. and he followed you. Who was driving the vehicle that you're in, Mr. Goins?
I was driving, sir.
You're driving. Okay.
Yep.
And I mean, I guess, he's following you. How far does he follow you for?
Well, the thing is, Your Honor, it's regardless of the follow part, it's the fact that he posted it on social media stating that criminal sex offenders shouldn't be allowed to go to the library.
Okay.
So, I mean, again, he's putting it on there that, showing that he's even following me as well. He's come out to the home as well. And
well, did he say your specific name in this social media post, or did he just post his opinion that sex offenders shouldn't be allowed to the library?
Well, he's already put that out there, Your Honor, when he's posting my name and information already on social media. He's already put that information out there. So therefore, to be harassment doesn't need to put my name on there. Especially
the definition of harassment under the electronic statute is if he posts something that he knows is someone else is going to transmit to you because they saw it on social media now, or something that is, I mean, when you say he posts it, you mean he posts it on where? His Facebook page or something?
On social media, yes, Your Honor.
Okay. And when he posts that, is it in the form of a message that goes to you, or is it just a public post where he's just offering his opinion?
It's not Your Honor, it's not about opinion.
Well, that's what you're saying.
No, anything that he posts about me like that, regardless of whether it comes to me, is still harassment. Under the statutory, it's still harassment.
Well, if it's not aimed to you, don't you have to go to his Facebook page to even see it in the first place?
His friends are sending it to us. The people are sending it to us, harassing us as well. He's got people coming out here stalking us.
Well, who are those people?
Again, his friends.
Well, how do you know they're his friends, and how do you identify them as his friends?
So we got, what do you mean? How do I identify?
Well, I mean, do they?
Because they're commenting, because when they send them, they're commenting on his Facebook post in regards to it.
Okay, so these are people online that comment on Mr. Colby's Facebook post, but I mean, are they forwarding it to you or?
Yes, Your Honor. Then they forward it to me as well.
And I mean, when they forward it to you, they tag you on it. Is that how they do it?
I'm not really big into all that stuff. I just know that we get the messages.
When you say we, I mean, you mean?
I mean, they sent it to me and they sent it to Miss Taylor as well.
Okay. And so you're saying, though, in some of the cases, the messages from them appear on your Facebook account.
Correct.
And what do those messages say?
Exactly what I showed you, what he's posting.
I mean, he's forwarding your record and registration information as a sex offender.
So I get that that's not, he could post that picture, but then when he continues to keep harassing me about it and putting things on there that's not true. I got a criminal record in Texas. That's not true. I don't have a criminal record in Texas at all, period. Never been accused of such thing like that. Okay. That again, that's harassment.
Did you attach a copy of the post where he says criminal record in Texas?
What's that?
Did you attach a copy of the post where he says that you have a criminal record in Texas?
I don't have it here in front of me, Your Honor.
Did you attach it?
I want to say I did, but I'm not 100% certain.
And I'm not pulling up the filing right now because I'm having a little bit of an issue with my online case filing here. But you think what he said in there to just what do you recall him saying?
He's posted it. He's posted on there that I'm a cousin raper, that I got a felony in Texas as well. He's posting about my fifth wheel, saying I stole a fifth wheel as well to people, which is not true. That was decided in Kent County and dismissed in Kent County. Again, he's posting things that's not true about me. That's inflammatory.
I mean, all these things, are they getting forwarded to you
Yes, sir.
Mr.
Yes,
Goins, okay, so you're saying not only is he posting it on his page, which you would have to go and look for and access, but you're getting copies of what he's posting because people who you think are his friends are forwarding them on directly to you in order, make sure you see it, in other words.
correct.
Who are the friends you're referring to?
At this time, I don't have their names.
How do you know that they are friends or doing it at the direction of Mr. Colby and not just, other people out there that, just do it on their own choice?
Again, Your Honor, any post that a person is posting on their own social media is still considered harassment.
Well,
It's not bound by the First Amendment of freedom of speech, Your Honor.
Well, my understanding of the statute is a little different in that if it's going to be found to be harassing but doesn't necessarily mention you by name in there. Now, do they mention you by name?
He's established that. He's established many, many times of who he's speaking about.
And then I guess the second piece of it is
my address. He's posted the stuff for 2.5 years. He's even posted it on post out in Sand Lake, Cedar Springs. He's posted my information throughout town. He's been talking about how I worked at Kelly's food service and stuff. So he's already given that information that he doesn't have to continue to keep saying it. And that's under the 750.411H. And there's case law based on that.
Right. Well, my read of that statute is that where it becomes a message that is something that can be actionable under the statute is, and it can be. I'm not saying that a post out there just on your own Facebook page can't be. Obviously, you can post threats, directed and say, "I'm going to go kill so and so on such and so a date," and that's improper. Arguably, you're posting that so that the other person can become aware of it. And that's really the key piece of it in my mind is when Mr. Colby posts it, but if he doesn't himself, message it directly to you, then, he has to know that someone else is going to message it directly to you. So he's trying to work around, in other words, the statutory language, because my view of a post in general is, well, Facebook is out there. We have our own personal Facebook pages. We post stuff on it, but it's anyone else's choice whether or not they look at that. In other words, you don't have to go look at Mr. Colby's page, or anyone else's page for that matter. No one has to be on Facebook. When it becomes intrusive is, when people forward on or send messages intentionally aimed at an individual. And you're saying that's happening here, not so much directly from Mr. Colby, but through his friends.
I mean, when I get it and I go and I do check and verify it and it's there. Yeah.
Well, you mean when you go check and verify it, you mean you go verify it on his Facebook page?
Absolutely.
Yes. See, that's where it originated. Okay.
He's still posting it.
Yeah, I think I understand. Right. Well, he's posting it, but again,
it's illegal and it's harassment towards me.
Well, I'm not certain that I agree with you on all those counts, but
the definition of stalking is a pattern of two or more separate non-continuous acts that show a continuously purpose intended to cause or actually causing a reasonable person to feel terrified, threatened, or harassed or intimidated.
I agree with you there.
Social media posts where respondent has posted comments about how many packages I'm getting at my doorstep by Amazon, all that stuff.
And you share the house with Miss Taylor?
Absolutely. I rent from her.
Okay. Well, I do know that,
I rent.
Yeah. I mean, some of that stuff is directed at her as well. How do you determine what's going to you and what's going to Miss Taylor?
It doesn't matter. It's still coming from him, Your Honor. So
well, it is, but if it's aimed at Miss Taylor, then.
But again,
I get it. And you're saying, well, I'm living at the same house. If he's threatening the house, I live there. It doesn't really matter which one of us. So I think I understand what you're.
It's harassment. Right.
All right. Well, I think I understand your argument. I'm not sure I agree with you 100%, but let me hear from Mr. Colby, let me take some testimony. Mr. Colby, if you would unmute, and I'm going to swear you in. Very good. All right. Thank you, Mr. Colby. Would you raise your right hand?
I can't see you, Your Honor. I'm sorry. Hold on a second. There we are.
Very good.
Yes.
Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Absolutely.
Very good. And Mr. Colby, you understand what Mr. Goins is saying here is that you're posting messages that are either aimed directly at him or that you intend to have someone else forward onto him and thereby constitute electronic harassment under the cyberstalking statute. What's your response?
Well, first of all, none of that's actually happening at all. And for two, he just admitted that he says he has a Facebook account, which sex offenders are not allowed to be on Facebook. At all, period.
I mean, I don't know I know
it's the rule of Facebook, Your Honor, for one. And for three, he says he rents from his friend, Angela Taylor. That is his 100% girlfriend. And the house that he's in, I own with Angela. And we are in the midst of a court battle in Montcalm County Court. And I do not have a rental agreement with this man at all, which Michigan law says both people on the deed, which I am on the deed and the mortgage of that house.
Well, I'm going to tell you, I can't get in the middle of that thing because that's a part and parcel of divorce proceedings that are ongoing up there. The property aspect of it is.
Yeah, but Your Honor, I do not stalk him, and he thinks it's his house, and they just trying to keep this whole thing going that they're tenants, but they're not, because his son also lives there, and him and her tell each other they love each other, and they sleep in the same bed together. I caught them in bed, and the fifth wheel camper he's talking about was stolen and still is considered stolen through the state of Michigan. He's never had a title to it, and it was on my property when it disappeared when I found out it was stolen.
Yeah, I got it. And I do remember some of the posts were about the fifth wheel, et cetera. I guess what I'm more concerned about
as far as me stalking him at the library, Your Honor, I don't stalk anybody. I've never chased him around. This man assaulted me and beat me so bad I had to have a 5-hour facial reconstruction surgery, Your Honor.
Was there a criminal case that stemmed out of that?
Yes, there was. And for some reason, the charges got dropped. But the prosecuting attorney in Montcalm County got fired over a bunch of stuff for not doing his job.
Okay. How long
He's assaulted me 2 times, actually, Your Honor. I can show you pictures if you'd like to see them.
No, I don't have to. But how long ago did it occur?
That was in late 2023 when he supposedly signed a rental agreement, which I am not on. And like I said, he lives in my house without my permission.
Got it. Okay. Well,
and he also...
I can't really weigh in on the property issue there. I guess what about your posts? And let's just take it within the last 6 months, because that's really
my posts are just general posts for one about anything.
Go ahead.
I don't post any names about anybody, but they're general posts because what this man has done to me and my family and destroyed our lives, and it's cost me over $100,000 in attorney fees right now. But I don't want anything to do with him. Your Honor, he was in prison for 8 years for molesting both of his 12 and 14-year-old daughters. And you think he's afraid of me? He outweighs me by 75 pounds and has already put me in the hospital 2 times.
No, I get it. And I don't think it's the case here where he is saying, I mean, he has
there's
said
no reason
for his life, et cetera. But really what I think it's more about is this idea of electronic harassment and messaging.
He's coming up with stories, Your Honor, just to try to keep a PPO against me so I'm not allowed at my house anymore. They've already moved all of my stuff off the property, which there's a case going on about that too.
Sure,
there's going to be more lawsuits with
him
and his girlfriend, Angela, coming after the house is settled too.
And I know you don't communicate with Angela because I think I've granted her, at least in the past, a PPO.
Yeah, which is all a bunch of lies, and I proved them all wrong.
I'm not going to delve too far into that because I think we're still in the midst of a hearing on it. But have you posted his registration info on the internet before?
Absolutely, because he lives in my house without my permission.
Okay, so what you've done is you've cut and pasted. What I could find if I went onto the source site, his information and charges and reposted those?
I only do it 1 time a year, Your Honor, because he lives in my house. I don't do it all the time. Okay. People in the neighborhood need to be warned that a child molester, a violent child molester, lives in the neighborhood.
Well, don't disagree that people ought to be warned.
Especially living in my
And you're
house.
saying you feel like, well, you're still a homeowner there because that is in your name and falls under your duty. So if I give you a pass on that one, what about the idea of, adding information to that, saying, for example, he's a raper of his cousins or daughters, or more information is in the public post. What about that stuff?
I didn't post any of that stuff, so I don't know what he's talking about.
Okay,
I
so
have been
that
in
I wouldn't
contact with
find
his
that in the
cousin.
post.
I have been in contact with a cousin in Texas that he stole the camper from, and yes, he did. He sent his sister down there to beat her up.
Okay, well, what about yeah, and I mean, he mentioned this criminal record, but you haven't said he has a criminal record in Texas.
No, I said he was wanted in Texas.
Wanted in Texas.
On the questioning of the rape of his cousin.
Okay, now, and I mean, is that public information? Is there a charge?
I believe so. I believe so. I've talked to his cousin. I think she filed charges. So,
and
I don't know. That was a couple years ago. So,
did you post it, Mr. Colby?
Not that I remember.
Okay, so that I wouldn't find that on your posts, anyways, that I'm getting from here, and I can't look at those right now from Mr. Goins as to exactly
right, because they don't exist, Your Honor.
Okay, and I guess my last question for you at this time, Mr. Colby, is: are you is someone one of your friends? Do you post stuff on there and then say you have them that you're aware of? They send it directly to him to kind of make sure he gets it in his inbox or something of that nature?
Absolutely not, Your Honor. I don't talk to people. I go to work every day at a respectable place, and I come home. I don't really have any friends anymore because of the situation him and Angela have put me in right now, and I take care of my kids. He's the main reason why his girlfriend lost 100% custody of her son, because he's not allowed to be around kids, and she would rather have a child molester in her house than her own child.
Well, I can say, I don't know exactly how those decisions get made, but it's not the first time. So, and really none of that's here. I guess the key is that, these messages of yours don't cross into that world of, cyber stalking or cyber
Absolutely not, Your Honor. He's just looking for a way to put a PPO out on me to keep disrupting my life and causing harm to me and my kids.
All right. Well, what I'm going to do is I'm going to deny the appeal at this time. I've heard testimony from both sides. The fundamental facts here are that Mr. Colby acknowledges he's reposted information from the SORA registry, however, has not posted additional or supplemental information. And Mr. Goins, I know you dispute that, and unfortunately, I'm not able to look at those right now. I'm going to go back and revisit those postings. I will caution you, Mr. Colby, that, it may, I don't know if there are cases out there on reposting, of course, the SORA registry is public information, as are all convictions in the state of Michigan, and particularly the SORA registry is there specifically so that people, neighbors, people that live in adjacent areas can have a fair warning, and that someone who has this conviction in their background is in their neighborhood. And of course, it also has all the other requirements that it placed on Mr. Goins. However, I will note that it isn't, a license to have someone like Mr. Goins just be kind of the public punching bag out there where people can just post whatever they want about him on the internet. I think there is probably a fair question as to whether or not you can repost, on a more public forum, because undoubtedly Facebook is, more public, just kind of more generally accessed, less regulated than the SORA forum is, or the SORA listings are. And I guess most important to me, allow all that additional commenting or adding information or, whatever it might be in terms of that. So I'm going to deny it for the time being, with a cautionary note that.
Your Honor, may I speak real quick, please?
Yeah, go ahead, Mr. Goins.
So he says that I attacked him the first time back in 2023.
Well, I don't want to go over that. That's old history.
But Your Honor, well, hold on a minute. He brought it up. I at least want to put it on the record. He came here to my residence. Okay,
it's my house.
But none of it's going to be. You're not. Yeah, Mr. Goins, I don't think you're asking for a protective order because you're afraid that Mr. Colby's going to walk over to your house and beat you to a pulp. I think it's more you're worried about him doing stuff online that harasses you. So I'm just trying to cut to the chase of what the case is about here. And that's what the basis for this thing is, you know, and I would add to that, I am also cautious, you know, in driving cases where people are following others in cars and things like that. Well, of course, you know, the roadways and stuff, library parking lots and libraries themselves are public areas.
Off to the side, Your Honor.
I get it. When you're out there, you are.
I was headed home from work, Your Honor. I seen him I don't even remember seeing him. So I drive through Cedar Springs every.
I will note that, you know, the one thing I am cautious about is, you know, that, you know, I get these frequently, you know, where so-and-so is, you know, revving up behind me or, you know, going into stuff that might be looking like road rage or threatening people with a vehicle. And of course, that would be very dangerous, not only for the two of you, but for anyone else who got caught between the two of you accidentally. So I would just be cautionary. If you do encounter each other in public, you know, just go about your business, go the other way, because, you know, it can escalate to a dangerous situation where there's bad blood, and there's no doubt there's bad blood here. And until this all gets sorted out up in civil court up in Montcalm County, I'm sure there's probably going to continue to be bad blood. But I don't think this warrants a protective order at this time.
I'm going to fill the case, Your Honor.
You're welcome to, Mr. Goins, and that would be directly to the Michigan Court of Appeals, my reviewers.
I'm going to definitely do that.
Very good. Good luck to you, sir.
Yep, absolutely.
And we are concluded.
All right. Thank you, everyone. Good morning. Please have a seat as we get started with this morning's sentencing. Mr. Keatson, you have the call.
Thank you, Your Honor. Court calls Pauline Loberg 25-1386.
Thank you. We do have Mr. Loberg here with us this morning, along with his attorney, Ms. Amy Lou Husted, who is the Deputy Director of the Public Defender's Office. Mr. Kerner is present, our elected prosecutor, bless you, along with Agent Twilliger from the Michigan Department of Corrections. Mr. Loberg was last before the court on March 12th of the year 2026, and on that date, he pled guilty to domestic violence third offense. As a result of that plea-based conviction, the Michigan Department of Corrections did prepare a pre-sentence investigation report, a sentencing information report. Ms. Husted had submitted for the court's consideration a sentencing memorandum, as well as a number of character letters submitted on behalf of Mr. Loberg. It is noteworthy to mention that before we got started this morning, Ms. Husted attempted to deliver to the court a second statement from the victim, but as it was so close to the time to start the proceedings, the court rejected it because it would not have time to give it the full weight of attention that it deserves. With that, Mr. Loberg, would you raise your right hand with me? Do you promise that you will tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. You may put your hand down. Mr. Loberg, did you get a chance to review the pre-sentence investigation report that the court had just referenced?
Yes, I did.
And your attorney, Ms. Husted, did she make herself available to you to answer any questions you might have or address any concerns you may have about the contents of that report?
Yes, she did.
As you read through the report, specifically with respect to the agent's description of the offense, was all that truthful and accurate?
Yes.
Thank you. Ms. Husted, on behalf of your client, Mr. Loberg, have you had a chance to review the pre-sentence investigation report?
I did, Your Honor, and I do have some proposed changes.
Very well, then. The court will receive your proposed changes.
The first proposed change is...
Can I just ask you to pause for one moment? We've got some traffic, which is okay. Department of Corrections is on site and making their way over to the jury box. Let's give them a moment to get in here and get settled. They appear to be settled. I'm very sorry. You may continue.
Thank you, Your Honor. Under the agent's description of offense, on the second page of the description of agent's description of offense, in the second paragraph, it says, he then told Rachel, I'll kill you right in front of her. He stated he will kill Rachel and his son, Christopher, if he had to, because he was not going back to prison. Rachel was escorted back to the defendant's bedroom, where she was assaulted more and forced to lie down with him. After speaking with both the defendant and Ms. Simpson, the defense counsel has determined that Ms. Simpson was not assaulted or battered in the house.
What's the problem here?
I don't know, Your Honor. I'm just
trying to meet with my client. I thought I'd bring him back to hold it. Okay. Sorry.
We're going to take a short break so we can figure this situation out. I'm very sorry, Ms. Husted. We'll get right back with you. Short break.
All rise.
Thank you, everyone. Please take your seats. We're back on the record of People v. Loberg. So what happened was, and I apologize, Mr. Loberg and Ms. Husted, Department of Corrections were not timely this morning, and so they came in late. Mr. Allen, the attorney, was trying to get access to his client with no problems there, and we just had to find a place where Mr. Allen could meet with his client. That was done. We are finished. We are back on schedule, and I apologize, Ms. Husted. You may continue.
Thank you, Your Honor. Do you need me to restate what I'd already?
Well,
it's in my sentencing memorandum, Your Honor.
What I got from you is that the victim had changed her story and would like the pre-sentence investigation report to reflect that she changed her story. Is that correct?
Yes, Your Honor. Essentially, we would like that statement to read, Rachel was escorted back to the defendant's bedroom where he requested her to lay down and she complied.
And what page is this?
It's the second page of the agent's description of offense in the second full paragraph.
Okay. The whole paragraph?
No, not the whole paragraph. Your Honor, if I could approach.
Yeah.
Have it highlighted.
Okay. Mr. Kerner, he then told Rachel, I'll kill you right in front of her. He stated he would kill Rachel and his son, Christopher, if he had to, because he's not going back to prison. This is all from the victim. Rachel was escorted back to the defendant's bedroom where she was assaulted more and forced to lie down in bed with him. And your position, it should read what, Ms. Husted?
That it should read that Rachel was escorted back to the defendant's bedroom where he requested her to lay down with him and she complied.
I see. Mr. Kerner.
I'd object, Your Honor. I think it should stay.
And I'm getting the feel here that the victim is a victim of power and control and manipulation. Could be only the explanation of why she changed her story from what she had originally told law enforcement. And her original statement, this court finds, is a truthful statement, and then therefore it shall stand.
Thank you, Your Honor. My next objection was to the victim's impact statement. In the victim's impact statement in the PSI, Ms. Simpson declined to give a victim's impact statement to the Michigan Department of Corrections Probation Department at the time of the pre-sentence investigation report when it was being prepared. Despite her declining to participate, the probation officer took it upon himself to essentially create a victim's impact statement for her and placed her statements that she had made closer to the incident in the victim's impact statement. I am asking that that be stricken.
Thank you, Ms. Houston. Mr. Kerner.
I think it should remain, Your Honor.
The problem with this, and I certainly have no problems with the Michigan Department of Corrections in trying to get an accurate report. The victim's impact statement is a statutory section that has to be made by the victim for that particular section. And it doesn't appear that she made a statement that should be included in that section. Agent Twilliger always goes above and beyond the call of duty to make sure that the court has everything it needs to accurately pronounce a sentence, but in this case, I just can't use a statement taken not intended as a victim's impact statement. So I think that the defense is correct, Agent Twilliger. I certainly have no problem with you putting that section somewhere else. And what the PSIR should read under victim's impact statement is that the victim declined to make a statement to the Michigan Department of Corrections, if that's the truth.
Yes, Your Honor. I'll make the change.
All right, thank you. Ms. Houston.
Your Honor, is he in fact going to put it someplace else? Because I would just want to know if because you said that he could, but Where would he put it under the?
Where did you get this information from, Agent Twilliger? Did you cobble that together from the?
She gave to me directly when she came in to report the incident.
Okay, here's the problem, and I understand how this happened. Mr. Loberg was on parole, supervised by Agent Twilliger, and after this offense occurred, this is what she told him, right? As to the parole violation, not necessarily this crime. Can you create a subsection statement made to the Department of Corrections while defendant was on parole?
Yes, I can put it in the additional information tab.
Okay. Will that work, Ms. Houston?
I was actually hoping to get it completely stricken, but
Well, I don't think so. I don't think it's justice to hide facts, right? I think that the report has to include everything, and I think Agent Twilliger wants it to be included, and it should be. We'll create a new subsection for it, and I think that sorts it. Mr. Kerner, do you agree?
I do.
Very good. Thank you, Agent Twilliger. Ms. Houston.
thank you. The last, excuse me, the last correction would be under substance abuse treatment. It states that the AANA self-help provider was Life 360 support group. Your Honor, I believe it should be Pure 360, which is a substance abuse support group. I believe, and only because I use it myself, that Life 360 is a tracking app that families typically use on their cell phones to track each other, family members, children, etc.
Agent Twilliger?
Yes, I know he was participating in that when he was on parole, so that was not verified, but that was what was written in the packet, so clerical just wrote it as it was written in the packet, so that change will be made.
Very well, thank you. I assume that people have no objection.
No objection.
Anything else, Ms. Houston, with respect to the report only?
No, Your Honor.
Thank you. Mr. Kearney, have you had a chance to review the PSAR?
Yes, Your Honor.
Do you have any changes you'd like to see made to the body of that report?
None to the body.
Let's go back, thank you. Let's go back to the defense and see if we have any scoring challenges to the sentencing information report or the SIR. Ms. Houston.
Yes, Your Honor. The defense would like to challenge OV7. It's currently scored at 50 points. We believe it should be scored at 0. This is a McGraw variable and can only be scored for the acts that make up the sentencing offense. Here, the defendant pulled his girlfriend out of her vehicle and struck her in the face because he was upset that she was recording their argument. When she fell out of the vehicle, she fell out of the car onto her face. It's unclear if the injuries to Ms. Simpson's eye were caused by the fall or by Mr. Loberg striking her. Even if the injury to her eye was from Mr. Loberg striking her, it was not designed to increase the amount of fear or anxiety felt by Ms. Simpson. The striking was the result of an angry impulse and not a logically thought out plan to torture Ms. Simpson or increase her fear and anxiety. The fact that Ms. Simpson is advocating in her letter of support to the client or for my client, we believe shows that she does not believe the assault was designed for excessive brutality, and we would ask that that be scored at 0.
Thank you, Ms. Houston. Mr. Kerner.
Thank you, Your Honor. It's unfortunate that she is advocating that this wasn't brutality, because I believe it was. In fact, she had an orbital fracture. There was bruising. He used methods, whether he punched her or caused her orbital fracture, he used instrumentality that go beyond the domestic violence. I believe that 50 points is appropriate, Your Honor.
OV7, the victim was treated with sadism, torture, excessive brutality, or similar gregarious conduct designed to substantially increase the fear and anxiety of a victim suffered during the offense. The variable is properly scored, in this case, under excessive brutality, as Mr. Loberg greatly exceeded the force necessary to commit domestic violence. The victim suffered a possible orbital fracture, whether he did it himself or threw her on the ground that caused it, to her left eye, injuries to her mouth. She lost at least one tooth, pain and abrasions in her knees and lower back, and bruising to her breasts and her kidneys. OV7 is properly scored at 50 points. Challenge will be overruled. Ms. Houston.
Thank you, Your Honor. We also would like to challenge OV8, which is currently scored at 15 points. We believe that it should be scored at 0. It is also a McGraw factor and can only be scored for the acts that make up the sentencing offense. The defense believes the OV8 cannot be scored because the entire assault occurred outside in the defendant's driveway. The defendant telling Ms. Simpson to go into the house while holding her cell phone and keys is a separate offense of unlawful imprisonment, which was dismissed as part of the plea agreement. As a separate offense, the unlawful imprisonment cannot be scored as part of the instant offense. Additionally, the defendant did not assault Ms. Simpson while they were inside his house. Finally, the instant offense in that the defendant pulled her out of her car and struck her in the driveway of his home. He lives in a neighborhood with multiple houses, and the act of pulling her out of the car made it look more likely that a neighbor or passerby would see the assault and call the police. Therefore, we believe that she was not moved to a greater place of danger, Your Honor, and we ask that that be scored 0.
Thank you, Ms. Houston. Mr. Kerner, your response.
I believe that it's correctly scored at, OV8 is scored at 15 points because he lured her from the safety of the vehicle.
OV18, a victim was escorted to another place of greater danger or to a situation of greater danger or was held captive beyond the time necessary to commit the offense. OV18 is only partially a McGraw variable. The McGraw rule applies to asportation, but not to holding someone captive beyond the time necessary to commit the offense. As to a captivity, the court is permitted and required to consider post-offense conduct. People v. Allen, 331 Mishap 587. It's a 2022 appellate decision. Here, the variable is properly scored under both asportation and captivity. Mr. Loberg lured the victim over by threatening to assault their son. Once she arrived, he pulled her out of the safety of her vehicle and into the yard where he assaulted her. After the assault, he kept her captive, preventing her from leaving and requiring her to lay on top of him so he would know if she attempted to leave. OV8 is properly scored at 15 points. The challenge will be overruled. Ms. Houston.
My final challenge, Your Honor, is OV19, which is currently scored at 10 points. We believe it should be scored at 0. First, the fact that the defendant was on parole at the time of the instant offense is not scorable per People v. Sowers. The cite is in my sentencing memorandum. Do you want me to read it into the record?
If it's in your memorandum, it is part of the record.
Okay. Secondly, the denial of culpability is insufficient to assess points for interference or attempted interference with the administration of justice per People v. Weird. And third, there were no threats made against Ms. Simpson to prevent her from reporting the incident to the police. Finally, OV19 cannot be scored for the defendant refusing to speak with the police per People v. Thompson.
Thank you, Ms. Houston. Mr. Kerner.
We believe it should be scored at 15 points because of the threat or use of force. He said he was going to kill her in front of the grandmother.
Well, the victim admitted to being too scared to talk to the police because Mr. Loberg would continuously threaten to assault or kill their own son if she reported him. So, yes.
May I just correct that it's not a child in common, it is only his son.
Oh, it's only his son.
Yeah, she's not the mother.
Well, nevertheless, he threatened to kill his son if she reported him. So 15 points would be scored on OV19, Mr. Twilliger. Any other challenges, Ms. Houston?
No, Your Honor.
Thank you. Mr. Kerner, do you have any guideline challenges?
I do, Your Honor. PRV 2 should be 30 points because of the prior, or no.
Ms. Houston?
Your Honor, I believe that is correct.
For the time being, it absolutely is. What we're talking about is the attempted R&O. The completed crime of R&O is a Class G offense, making its attempt a Class H offense. PRV2 considers all convictions in classes E through H. That challenge should be sustained. Agent Twilliger, 30 points on PRV2.
Yes, Your Honor. Any
other challenges, Mr. Kerner?
Yes, Your Honor. OV10 should be scored at 15 points because of the predatory conduct by luring her son.
Ms. Houston, your response?
Your Honor, I object to that scoring. I do not believe that he lured her there. He did have multiple attempts to contact her. He did not realize that she was asleep. And Your Honor, I do not think that rises to the level of predatory conduct. I ask that it remain at 5 points.
Well, again, Mr. Loberg threatened the victim by threatening to assault his son. And so OV10 should be scored at 15 points for predatory conduct. Any other challenges, Mr. Kerner?
No, Your Honor.
Agent Twilliger, add him up.
The new total PRV score will be 110, stays at a level F. The new total OV score will be 110, and that stays at a level 6. The sentencing guidelines stays at 24 to 38.
24 to 38. All right, thank you. So we're sorted. We went through the PSCR, went through the SIR. Mr. Kerner, do you have a victim that wishes to address the court?
I believe one's here, but they've refused to speak with our office.
Oh, very well then. Allocution, Ms. Houston.
Thank you, Your Honor. Your Honor, Mr. Loberg is, he's had a difficult life. Growing up, we pulled his Shiawassee health and wellness records, and he had identified a number of adverse childhood experiences as indicated in those medical records. We do have those available if the court would like to review them. That included a neglectful home environment, physical abuse, emotional abuse, exposure to domestic violence, parental substance abuse, lengthy separation from the primary caregiver, and impairment of the parents due to mental illness. So he had a chaotic childhood, which likely played a large role in his personality development as well as his mental health development. Your Honor, he himself has been diagnosed with bipolar disorder and related disorders, including anxiety disorder and an unspecified personality disorder. He is on medications for his bipolar disorder. He had gotten out of prison and was on parole. He was working with Shiawassee Health and Wellness, and he also started Stratera for some attention difficulties. He's been working with Shiawassee Health and Wellness since his release onto parole. He was doing therapy, medication management, and working with a peer support specialist. Your Honor, he was trying very hard to make serious changes to his life to avoid the revolving door, so to speak, that he has been experiencing with going in and out of the Michigan Department of Corrections. Positively, Christopher has family support from his grandmother, Beverly, and his sister, Nikki. He has also several other friends and family members. He has stable housing with his grandmother. He was receiving Social Security disability and was also working part-time at Fast Eddie's prior to the instant offense. We believe that Christopher, he may be able to get that job at Fast Eddie's back upon his release from incarceration. We believe that it is important that he has the forgiveness and support of the victim in this case, Rachel Simpson. All of the letters that we submitted all indicate one thing, that Christopher needs help. He needs mental health support and treatment. We had applied him to this court's mental health court. I understand the court is not inclined to bring him in, but we are asking for a sentence that is treatment oriented so that he can, get stabilized on his meds, get that therapy, work through his trauma, and not have this sort of thing happen again.
Thank you very much, Ms. Houston. I appreciate the amount of work that you put into this matter. Mr. Kerner for the people.
Thank you, Your Honor. This is, as the court said, a classic situation of power and control. Mr. Loberg's violent. The only fortunate thing about this situation is that we don't have someone who's been killed. I mean, this is a dangerous situation. We are lucky that the victim wasn't more seriously injured. I'd ask the court fashion a sentence that focuses on punishment and deterrence and send him to the Department of Corrections, Your Honor. Thank you.
Thank you, Mr. Kerner. Mr. Loberg, this is your opportunity to address the court. What would you like to say?
I'd like to say that I regret my actions that day and letting my emotions control me. And I'd like to apologize to Rachel, my family, in this court. I'm sorry. And that's all for now.
Thank you. I start looking at your criminal past. 5 felony convictions, 16 misdemeanors. At least 9 of these convictions were assaultive in nature. Many other were charged as assaultive, but pled down to something like, not assaultive. You were sent to prison for this type of behavior. You were paroled and you continued this type of behavior. Your parole agent, as according to the report that you said was accurate, ordered you not to have any contact with your victim. You disregarded that. According to the report, you continued to have contact with that victim well after you were incarcerated and continued to have contact. Although, no, I'll strike that. I don't think there's any evidence to support that you had contact with her while you were in jail, but you certainly did before you were lodged, which is troublesome. And somehow you've managed to convince your victim that you didn't do anything wrong, and that you've got a condition that could be treated and cured. As she likens your condition to that of a drug addict or an alcoholic, and with treatment, you'll stop hurting people. I don't know about that. I don't know what the public would think if we started a treatment court to help people that won't stop hurting other people, which leads me then to your rejection of participation in a treatment court. I'm not permitted to bring anybody in a treatment court that I don't believe could be safely managed in the community. And I do not believe I can safely manage you in the community, Mr. Loberg. You are dangerous. You are next level dangerous, not only physically, but you mentally beat your victims. You've had your victim turned around so she would write letters and explain that it's not your fault, that it's hers, and that's dangerous. It's dangerous, especially when all this behavior occurred while you were on parole for doing the exact same thing. It doesn't seem like you would benefit from any kind of community supervision, and I don't think it'd be safe for the community to have you out in it. So, Mr. Loberg, there'll be some financial obligations, and that includes a crime victims assessment in the amount of $130, court costs in the amount of $961, and a $68 state cost as ordered by the court. As to your sentence, Mr. Loberg, you will spend a minimum of 38 months in the Michigan Department of Corrections, not to exceed 60 months. You'll receive no jail credit. In fact, you will not start this prison sentence until the Michigan Department of Corrections discharges you from the sentence for which you are currently serving. Agent Twilliger, please include in Mr. Loberg's packet directions to the Michigan Department of Corrections that Mr. Loberg should undergo a mental health evaluation, and Mr. Loberg should follow those recommendations.
Yes, Your Honor.
You do have some appellate rights. Mr. Schmidt will be along to present them. Please initial them, acknowledging that you've received them if you'd like court-appointed counsel to assist you with an appeal. You've got 42 days from today's date to make that request. Thank you, everyone, very much. Mr. Johnson is making his way up to the podium where he will meet his attorney, Ms. Amy Lou Houston, Deputy Director of the Public Defender's Office. Mr. Kerner is present. He's our elected prosecutor, and Agent Twilliger from the Michigan Department of Corrections. Mr. Johnson was before the court last on March 12th of the year 2026, and he pled guilty to the following. Of the then existing information, he pled guilty to count 5, fleeing and looting a police officer, 3rd degree. Count 8, malicious destruction of fire or police property. Count 11, resisting and obstructing a police officer. And count 12, resisting and obstructing a police officer. As a result of those plea-based convictions, the Michigan Department of Corrections did prepare a pre-sentence investigation report as well as a sentencing information report, distributed those documents to the parties and to the court. Ms. Houston, on behalf of Mr. Johnson, did prepare and submit a sentencing memorandum, which the court has considered. With that, Mr. Johnson, would you raise your right hand with me, please? Do you promise that you will tell the truth, the whole truth, nothing but the truth? So help you God.
Yes, sir, Your Honor.
Meg, you may put your hand down. Mr. Johnson, did you get a chance to read the pre-sentence investigation report that the court just referenced?
Yes, and Miss Amy went over it with me as well.
All right. And she made herself available to you to talk about it, answer any questions?
Sure, she did.
All right. And as you read through it, did you find everything in it truthful and accurate?
Yes, I did.
Thank you. Ms. Houston, you got a chance to review the PSIR.
I have, Your Honor.
Any changes you'd like to see made to the body of that document?
2 small changes, Your Honor. The first is under family. His sister, Sherry Draper, is listed as living in Nashville, Tennessee. She actually lives in Nashville, Michigan. We would ask that correction be made.
Agent Twilliger.
Yes, Your Honor.
Thank you.
The second one is under the employment narrative. It says the only other employment noted by the defendant was working at DJ Root from 2017 to 2019 at $9.24 per hour part-time. We are asking to correct the years. It was 2017 to 2018.
Agent Twilliger.
Yes, the correction will be made.
Mr. Kerner, if you have an objection, just let us know.
I'll speak right up.
I know you will. Ms. Houston.
Those are the only two corrections to the body of the report, Your Honor.
Thank you. Mr. Kerner, have you had a chance to review the pre-sentence investigation report?
Yes, Your Honor.
Do you have any changes you'd like to see made to the body of that document?
None to the body.
Let's stay with the people and take a look at the sentencing information report. Mr. Kerner, do you have any scoring challenges?
Yes. OV 10 should be 0 points.
Ms. Husted?
Yeah, I would concur, Your Honor.
Check that. Mr. Twilliger?
Yes, Your Honor.
Mr. Kerner?
And OV 13 should be 0 points because we scored 25 in OV 12.
Ms. Husted?
Yes, Your Honor.
Check that. Mr. Twilliger?
Yes, Your Honor.
Mr. Kerner?
And OV 19 should be 15 points because there was an officer that was injured during the interference with justice.
Ms. Husted?
I would concur, Your Honor.
Very well then. Agent Twilliger, 15 points for OV 19.
Yes, Your Honor.
Thank you. Any others, Mr. Kerner?
No, Your Honor.
Ms. Husted, do you have any scoring challenges to the SIR?
Mr. Kerner actually stole my thunder and took my OV 10 and OV 13 away from me.
These are originally Ms. Husted's challenges, but that's okay. Efficiency, right? That's good. Add them up, Mr. Twilliger.
The PRV totals stay the same. The new OV total is 75, still level 6, and the sentencing guideline range remains 19 to 38.
Thank you. Do you agree with the math, Ms. Husted?
Yes, Your Honor.
Mr. Kerner?
Yes, Your Honor.
Elocution, Ms. Husted.
Thank you, Your Honor. Your Honor, Mr. Johnson was adopted out of the foster care system by Margarita and Gerald Draper. He received special education services while in high school. He's very proud of the fact that he did graduate high school. He currently has little to no contact with his adoptive siblings. He also has 2 sons, and he has basically no contact with them either. He reports a diagnosis of developmental disability, depression, and bipolar disorder. He was receiving disability payments of $968 a month prior to his arrest. He was able to support himself and maintain stable housing with that income. He does not own a car, so he normally walks everywhere. Occasionally he is able to get a ride, but he rarely drives. In the instant offense, he was driving his girlfriend's car at her request. And he reports that he had never been pulled over before by the police. And when the police officer attempted to pull him over, he panicked. And his actions were the result of panic and fear, and certainly not any sort of logical thought, Your Honor. He would like to get help, continue to get help with his mental health and medication management to control his depression and anxiety and bipolar disorder, so that he can make sure that nothing like this ever happens again in the future.
Thank you, Ms. Husted. Mr. Kerner?
I'd categorize Ms. Husted's description a little different about him just panicking. I mean, he's created danger to the officers. We had to get a taser out, and he's yelling F you to the officers, and that sounds more like a belligerent fight than a panic to me, and he fled, creating danger, Your Honor. I'd ask that you fashion a sentence that focuses on punishment and deterrence, and send this gentleman to the Department of Corrections.
Thank you, Mr. Kerner. Mr. Johnson, this is your opportunity to address the court, sir. What would you like to say?
And I'm sincerely sorry, Your Honor, for my actions. And then, like Miss Amy just said, I would like to continue getting help that, if that's possible, Your Honor, to where I don't have no future actions like this.
Thank you, Mr. Johnson. As I read through the incident that you said was accurate as contained within the report, it was just mayhem. A number of different officers tried to stop you using pit maneuvers. Those strips with the spikes on them. You nearly ran over bystanders. You hurt an officer. And then when they finally got you, they had to tase you to get you out of the vehicle. It was mayhem. It was incredibly dangerous, for not only for you, but for the officers and for bystanders who didn't do anything to you. It was a very, very scary situation. And I think that everyone is very fortunate that we're not here scoring guidelines on a death, or a serious injury. You included, Mr. Johnson. There'll be some financial obligations, starting with count 5. $130, crime victims assessment, court costs in the amount of $961, DNA testing fee of $60 and a $68 state cost. As to count 8, there'll be a $68 state cost. As to count 11, a $68 state cost, and count 12 is $68 state cost. As to incarceration, Mr. Johnson, I'm sorry that you had a tough time growing up. I really am, but that just is not an excuse for the scene that you caused on this day and the amount of destruction and fear that you caused. As to count 12, it's a sentence of this court that you spend a minimum of 16 months in the Michigan Department of Corrections, not to exceed 24 months. As to count 11, it's a sentence of this court that you be sentenced to the Michigan Department of Corrections for a minimum of 16 months, not to exceed 24 months. As to count 8, it's a sentence of this court, and now we're on the malicious destruction of fire property. It's a sentence of this court that you serve a sentence not less than 16 months, not to exceed 4 years. And as to count 5, fleeing and eluding third degree, it's a sentence of this court that you serve a period in the Michigan Department of Corrections for a minimum of 24 months, not to exceed 60 months. Against all of those sentences that will run concurrent, you'll receive credit of 160 days. You do have some appellate rights. Mr. Schmidt is along to you with some appellate rights. Please initial them, acknowledging that you received them. If you like court-appointed counsel to assist you with an appeal, you've got
Your Honor.
Yeah, right there. You've got 42 days from today's date to make that request. Good luck to you, sir.
And bring it up here with Miss Amy.
Yep.
Thank you.
Do you need help?
You said initial, Your Honor?
Yep, just initial. That's fine. You got it.
That's the only one, Miss Amy?
Yep, that's the only thing you got to do right now.
Okay.
Okay,
There, sir. Thank you.
okay, we're all set.
I will note that the 150 case in Greenwood County, the matter is actually set for arraignment today. Mr. Favre, does your client desire the charging document to be read to him?
Judge, he would waive a formal reading, and we are ready to proceed with a plea in both cases today.
Okay.
Okay. So, Judge, would you like to start with the Greenwood case or the Elk County case?
Greenwood.
Okay. The Greenwood case, Judge, Mr. Comstock will be pleading guilty to counts 1, 3, and 5 of the information. That is interference law enforcement level 9, possession of marijuana, class B, and criminal possession of a firearm, level 8. State will agree to dismiss remaining counts. At sentencing, Mr. Comstock will be presumptive prison on these, and the recommendation that the case will be that the cases run concurrent as allowable by law to his current case.
All right. The announced agreement in regards to the Elk County case?
Judge, in the Elk County case, the state will file an amended information that reflects a count 1 of attempted aggravated assault at law enforcement. That's a level 8 person felony. Mr. Comstock will be pleading guilty to that amended count 1, as well as an amended count 2 of flee and elude, a class A person misdemeanor. I apologize, that should be a class B, I believe, person misdemeanor for the flee and elude. And state will agree to dismiss count 3 reckless driving. Again, the agreement at sentencing will be that that case will run concurrent as allowable by law to his other cases.
So this agreed upon amended charge of attempted aggravated assault is intended to be a level 8 person felony, Mr. Favre?
That is correct, Judge, yes.
All right, Ms. Gillette, are you disputing anything that Mr. Favre has announced?
You're muted, Jill.
No, Your Honor. The only thing was I was looking up the flee and elude, and a first time is a class B. So yes.
All right. All right, Mr. Comstock, I've got a series of questions I need to ask you regarding the taking of a felony plea. If there's anything you don't understand, I'll give you the opportunity to confer privately with Mr. Favre again, if you need to, okay? Okay, you're muted as well.
Okay, Your Honor, thank you.
State your full legal name for the record.
JD Comstock,
How old are you right now?
41,
What's the highest level of education that you've attained?
my GED.
Okay, do you think you're going to have difficulty understanding the legal concepts we're going to go over today?
No, Your Honor.
Have you ever been adjudged to be mentally ill?
No, Your Honor.
Are you currently under the influence of alcohol or any drug?
No, Your Honor.
Are you currently taking prescription medication?
Yes, sir.
What are you taking?
I take gabapentin for my paralyzed arm.
Okay. Does that in any way negatively affect your mental state where you can't understand what's going on?
No, sir.
Okay. Do you believe your mind is clear currently and you have a full understanding of what's going on in court?
I do.
Okay. Have you received copies of the charging documents in these two cases?
Yes, sir.
You understand that when you enter pleas of guilty, you are admitting the acts that are in the information which are charged in these two cases?
I do.
Okay. You also understand that when you enter pleas of guilty, you give up any legal defenses that you might have had to those charges?
Yes, sir.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, and that you could present evidence at your trial on your own behalf and subpoena your own witnesses to court?
I do.
You also understand that in such a trial, you personally would have a privilege against self-incrimination, which means you could testify at your choice, but no one could force you to testify against yourself if you didn't want to. Do you understand that?
Yes, sir.
You understand that when you enter pleas of guilty, you give up valuable trial rights, which the court has described.
Yes, sir.
Are you aware that you have a right to a trial by jury, and before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes, sir.
You understand, Mr. Comstock, that when you enter pleas of guilty in these cases, you're waiving your right to jury trials and the requirement that you be found guilty beyond a reasonable doubt.
Yes, sir.
And you understand that you have a right to appeal a guilty verdict if you have a trial?
I do.
You further understand that you may appeal your sentence after entering pleas of guilty, but generally you may not appeal judgments of conviction after you enter such pleas.
I do.
Now, are you aware of the sentences that could be imposed on these varied charges that you're pleading to here today?
I am, sir.
All right, let's go over those. Start off with the Greenwood County case. Count one is interference with law enforcement, a level 9 non-person felony. In the most favorable criminal history category of I, you could receive as little as a 5-month prison sentence. In the worst criminal history category of A, you could receive up to a 17-month sentence. So the sentencing range is 5 to 17 months in prison on that charge. You could also receive up to a $100,000 fine for that offense. On count 3, a Class B non-person misdemeanor, possession of marijuana, that's punishable by up to a $1,000 fine and up to 6 months in the county jail. Regarding count 5, criminal possession of a firearm, a level 8 felony, that's punishable by a minimum sentence of 7 months, but up to 23 months prison if you're in criminal history category A. So the sentencing range there is 7 to 23 months, again, depending on your criminal history score. You also could receive up to a $100,000 fine for the level 8 felony. You understand the possible penalties in the Greenwood County case?
Yes, Your Honor.
Regarding the Elk County case, the attempted aggravated assault would be a level 8 felony. You understand that it would also have the penalties of 7 to 23 months in prison, depending on your criminal history.
Yes, sir.
Okay. You also could receive up to a $100,000 fine for that offense. I didn't hear the response.
Yes, sir, Your Honor.
Count 2 The attempted fleeing and attempting to elude a police officer, a Class B misdemeanor, would be punishable by up to 6 months in the county jail and up to a $1,000 fine, or both. Do you understand that, Mr. Comstock?
Yes, sir.
Okay.
Judge, count 2 is flee and elude as a misdemeanor. There's no attempt on it. It's just flee and elude as a misdemeanor.
Okay, I'm just looking at your charging document, counsel. It says fleeing and attempting to elude a police officer.
Okay. Yeah.
Okay. All right, Mr. Comstock, in addition to any fines, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any
Yes,
are
Your
owed
Honor.
as part of your sentencing orders?
Yes, sir.
You also understand that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is the state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing.
Yes, Your Honor.
Do you understand that both probationary and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances?
Yes, sir.
You also understand that the Kansas Sentencing Guidelines Act contains special rules. And do you understand that if any special rules apply to you in your situation, it could affect your eligibility for probation or otherwise affect your sentence?
Yes, Your Honor.
I didn't hear the response.
Yes, sir. Yes, sir, Your Honor.
Okay, I'm getting an unfortunate message that my internet connection is unstable. So, Mr. Comstock, can you hear me?
Yes, Your Honor.
Okay. I want to ask you again about special rules. Do you understand that if any special rules apply to you, it could affect your eligibility for probation or otherwise affect your sentence in these cases?
Yes, Your Honor.
Okay. Now, did you have an ample opportunity to discuss your legal matters with your attorney, Mr. Favre, before proceeding here today?
I did.
Do you want any more time with him privately now before we go further?
No, Your Honor.
Are you satisfied with the services and advice given to you by your lawyer?
Yes, sir.
Okay. Now, these guilty pleas that you're attempting to make, have they been based upon any threat or promises as to what this court will do in regards to your sentences or any other type of threat or promise?
No, sir.
Okay. You understand that if there are any plea agreements between your counsel and the county attorney's office, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes, Your Honor.
Okay. So let me ask you, in regards to the Greenwood County case, how do you plead to count 1, interference with law enforcement?
Guilty.
Count 3, possession of marijuana?
Guilty.
And criminal possession of a firearm in count 5?
Guilty.
All right. According to the state's charging document, the matters in that case took place June 29 of 2022. Is that when they happened?
Yes, Your Honor.
And they happened somewhere in Greenwood County, Kansas. Where was it?
I believe it was here, close to Ozarka. I'm not sure, Your Honor. I'm not from here. I'm from Arkansas.
Okay.
I believe it was in Ozarka.
Okay, I don't know where
Or
that is,
Eureka.
what it
Excuse
is.
me. Eureka. Close to Eureka.
Okay, you mean the city that you're currently housed in right now?
Yes, sir.
Okay. All right.
Yeah. Highway 400.
All right. You gave some false information to officers on that date?
Yes, Your Honor.
What was it?
False name.
Okay. And that hindered the investigation of the officer at the time, did it not?
Yes, sir.
And you were in possession of marijuana on that date?
Yes, Your Honor.
Where was the marijuana?
In the car that I drove.
And you knew it was there?
Yes, Your Honor.
Okay. Then in count 5, you were in criminal possession of a firearm. What kind of weapon was that?
It was a pistol in the vehicle that I was driving, Your Honor.
Have you been convicted of a felony within 10 years before then?
Yes, Your Honor.
So you acknowledge to the court that that was criminal possession of a firearm, do you?
Yes, Your Honor.
Okay. Turning to the Elk County case. It was alleged that these incidents took place on June 30 of 2022. Is that when the attempted aggravated assault happened?
Yes, Your Honor.
It happened somewhere in Elk County, Kansas. Do you remember where that was?
It was at a dollar store.
In Howard?
I believe so. Yes, sir.
Okay. And you attempted to assault a law enforcement officer on that date?
Yes, sir.
Involving a motorcycle?
Yes, Your Honor. I attempted to flee away from him.
By going through him on the motorcycle?
He was in the path of the motorcycle, and it caused fear.
Okay. And on that date, do you acknowledge to the court that you fled or attempted to elude police officers by trying to pull away from the scene on a motorcycle?
Yes, Your Honor.
All right. So do you now freely, knowingly, and voluntarily enter pleas of guilty and accept conviction for interference with law enforcement, level 9 non-person felony in count 1 of the Greenwood County case, count 3, class B non-person misdemeanor possession of marijuana in that case, and then also criminal possession of firearm, a level 8 non-person felony in count 5 of the Greenwood County case?
Yes, Your Honor.
Do you now freely, knowingly, and voluntarily enter pleas of guilty and accept conviction for, in the Elk County case, attempted aggravated assault, a level 8 person felony, again in count 1 of that information, and then amended count 2, class B misdemeanor, fleeing and attempting to elude a police officer?
Yes, Your Honor.
Okay. Gillette, do you know of any legal reason why the court shouldn't accept this defendant's set of pleas here?
No, Your Honor.
Mr. Favre, are you aware of any such legal reasons?
I'm not, Judge, no.
Mr. Comstock, are you aware of any legal reason or any other good reason why the court shouldn't accept your pleas?
No, Your Honor.
The court will accept the guilty pleas made by the defendant respectively in these two cases, finds that those pleas are made voluntarily. He has an understanding of the nature of the charges against him and the consequences of the pleas, and a factual basis for each charge does exist. The court finds him guilty and adjudges him therefore convicted in the Elk County case in count 2 of fleeing or attempting to elude a police officer, class B misdemeanor, attempted aggravated assault, a level 8 felony in count 1 of the Elk County charging document. Now, the court also accepts pleas and finds him guilty at this point with interference with law enforcement, a level 9 non-person felony in count 1, unlawful possession of marijuana, a class B misdemeanor in count 3, and criminal possession of a firearm, a level 8 non-person felony in count 5. Other charges of these charging documents are dismissed in total pursuant to plea agreement. Court orders a pre-sentence report, an investigation regarding the various charges that have been accepted by this court pursuant to the defendant's guilty pleas, and the court will set an appropriate date for sentencing. Court will do sentencing at the same time. Favre, I'm looking at the afternoon of Thursday, June 25. I'm suggesting 2 o'clock.
I would probably need to go earlier, like 1, or later, like 4:30.
1:15.
1:15 works.
Court assesses the Comstock sentencing dates. That is both the Greenwood and Elk County cases. 1:15 Thursday, June 25, contemplated to be done by Zoom. All right.
Judge, you said June 25 at 1:15.
Yes.
Thank you.
Mr. Comstock has a DOC hold, so his status is clear at this point that he's going to be held in custody pending that sentencing date. Mr. Comstock, I would hope that if the court services office or community corrections, whoever needs you to do an assessment or otherwise need your cooperation on the pre-sentence investigation, that you will give it.
Yes, Your Honor.
All right. Mr. Favre, is there anything else we need to address currently?
No, Judge.
Ms. Gillette, anything further at this time?
Not on Comstock.
All right. Mr. Comstock, do you have any questions regarding what we've done here today?
No, sir.
Very well. Then if there's nothing further at this time, the JD Comstock matters will currently be in recess, and this meeting may be ended for all at this time.
Thank you.
And this meeting may be ended for all. I'm trying to look and see what I have on for tonight. I'm 90% sure we're watching Judge Oakley tonight. And I'm trying to remember exactly what for tomorrow. I have everything out here planned. Now it's all missing. I'm not sure what day it is. Definitely Oakley. And Sunday? What is Sunday? Judge Hart property case dispute, I think. Dispute, something about Judge Hart and property fraud and all that type of good stuff. Anyway, ladies and gentlemen, thank you for coming out. I'm your lone wolf Usul. I do these crazy little things on the weekend and every single day. 8 p.m. Central Time, 9 p.m. Eastern Time. We all get together. And 8 p.m. tonight, we'll be doing a premiere. 8 p.m. tomorrow night, we'll be doing a premiere. That was what I was trying to look up the information for because I didn't have it right here at my fingertips. But ladies and gentlemen, chat has been amazing today. Thank you for hanging out with me. Thank you for participating and talking with our new friend Lone Wolf Bot over here. He's been a blast. And I do want to say a special shout out and thank you to our contributors today. You've all been awesome. Sally Port, thank you so very much for your contributions. You're also amazing. Chat, you've been great. And I really don't know what to say. We need Wolfbot to give us the dad joke. We need a good dad joke for the outro, right? All right. Is that one worth anything? What do y'all think? It's a dad joke. Why did the Scarecrow win an award? Because he was outstanding in his field. Oh my dear Lord. Y'all stay weather aware. The weather's crazy out there. Go watch some Ryan Hall, y'all, and make sure you're up to date on what the weather's doing in your local area. For now, I'm your lone wolf Usul, and I'll say see you tonight at the premiere. Me and Wolfbot will be there. I hope to see you there. And by the way, an update on the turtle. I picked him up and carried him way out in the backyard. The dogs had a ball playing with him. He got up in his shell and the dogs were picking the shell around. It was a whole thing. I should have had it on camera, but I didn't. That's just what happened with the turtle. If you're confused about what I'm talking about, go back and read some of the chat from earlier. Ladies and gentlemen, y'all have a great afternoon. I'm your lone wolf Usul, and I am signing out. Don't be creepy, but always be weird.